All right, welcome to Life in the Law. Again, my name is Ken Lawson. I teach law at Law School, and I have two guests with me today, and today we're going to talk about the Deedy trial. And I have two of the best defense lawyers in the state, really, that's actually in the nation, and I say that without, with all seriousness. I mean, you guys are well respected, you've earned your stripes, you've been recognized by your peers as being the top lawyers in this state. And I've seen a lot of lawyers in the country, and in my opinion, you're two of the best in the country. So I'm glad that you guys agreed to come on our show.
Thank you.
We have William Harrison and Myles Breiner, and I'll let you guys introduce yourselves and kind of tell a little bit about your background, and then we'll get into the case.
Yeah, primarily I practice in the criminal defense area. I've been doing it for 33 years now. I'm also an adjunct professor, along with yourself, at the William S. Richardson School of Law and Innocence Project. And so this topic is right up my alley.
Well, Bill is actually senior to me, so I've been practicing about 30 years. I was a deputy prosecutor here in Honolulu, and before that, an assistant district attorney in California. Primarily, I'm focusing on criminal defense in my practice for the last 25 plus years.
And both of you all have handled some high-profile cases in your practice. I mean, I see you guys on the news a lot. And this Deedy case is a high-profile case. Is there anything different about handling high-profile cases than your normal run-of-the-mill case that no one knows about?
Well, absolutely. You know, you have to deal with the press and the media. You have to deal with the influences that they have on potential jurors, because you know, our population of jurors come from our community, and if there's only one newspaper here that prints the news, and there's a couple of news stations, one of which has 2 or 3 different channels, but the same news. So, in effect, they have a lot of influence on what people believe has happened in cases before we get to court. So we have to deal with that.
I mean, the fact is, the court instructs jurors all the time: don't read the news, don't go online, precisely because they do exactly that.
Yeah.
It's a small community. Everyone knows everyone else. That's compounded by the fact that we have a limited media. You know, as Bill said, the television media is dominated by one station primarily. We have one newspaper, and people talk. And you have to, the more high profile the cases, the more you have to worry about the well being tainted. You see the police officers more frequently than not in high profile cases will hold a press conference and discuss the facts of the case to influence the public sentiment about your client. And we as attorneys can't do that. We know that.
I was going to ask you that question. Do you think there becomes a duty on your part at that point to at least say, I mean, lately, and Barry Scheck spoke at a CLE conference about it also, there seems to be some support that there's a duty, an ethical duty for you to respond publicly when the press is really, or the police or prosecution is in the press talking against your client.
Well, I know when I see Bill on television, he's being an advocate. But it's a fine line. In some respects, I think we as defense attorneys are held to a double standard. We have to be very careful that we don't say that we believe, for example, our client's innocent. We can say our client has pled not guilty and is presumed innocent. Mm-hmm. I've actually had complaints filed with the disciplinary counsel for simply stating, in my opinion, my client's innocent. So it raises it's a fine line. So you have to be very careful, and you're right. If the police or the prosecutors are holding press conferences and endorsing and certifying the prosecution of your client, then it's almost incumbent upon you to do something to set that different tone. But you have to be careful. You don't want to disclose too much, but at the same time, you want to make sure that you get your story out there, so at least your client, you know, gets a shot. I think for any defense attorney, all you ask for in court is an even playing field. That's all you ask for. An opportunity to present your case, you know, in an unbiased format. And you're constantly weighing the problem with the judges who are many ex-prosecutors, judges who have reputations as being pro-prosecution, and it makes it difficult because you run into the prosecutor and having a second prosecutor as a judge.
Yeah, definitely. You need to, especially in these kind of high-profile cases, you need to tilt the playing field, absolutely. And the problem is that, as Myles says, if you're too much of an advocate, then you run into problems. But you know that the other side, the government, the prosecutor, and the police, are moving in that direction to obviously help their case ultimately in court, and you have to combat that. and that presents a real problem for our
Let's
clients.
talk about the Deedy case real quick. Do you think the publicity in that case, we had a videotape, and we're going to get to how do you present videotape evidence? How do you argue that in court? And is it important when you have videotape evidence? Does that make the case that much closer? But do you think the publicity, how do you think it played a role in the Deedy case, if any?
Well, clearly, you know, you had sides that had taken positions in the case. You had a local community was out, you know, an outrage because an individual from the State Department came to our islands and shot and killed one of their own. And on the other side of the coin, you have the conservative law enforcement individuals that say that in that situation they have a right to brandish a weapon and to defend themselves in that context. And so the media blitz kind of polarized different segments of the community, and you worried about that when you saw the case unfolding for purposes of trial. Like, how could you get a fair trial in that situation? That's clearly what we are concerned with when we defend our clients.
You know, and there's an added dimension to this case. In addition to having a video, and the video, it depends on the eye of the beholder, what the video express, what did it demonstrate. But you also have what's going on the outside, where you have the victim's family retaining an attorney, and that attorney, a very effective advocate, orchestrated a separate campaign on the outside, generating media attention regarding the death of the victim. So you're contending with an ongoing kind of media circus that is playing to the prosecution case to push the case to trial, to keep the public attention on it, to keep reiterating the facts that are favorable to the prosecution, which is favorable also to the family that's filing a civil suit. So it presents a series of problems that a defense attorney has to contend with. You don't want to get out there and insult the deceased. You don't want to engender more anger that you've said something negative about the person who was shot and killed. Although you have ample evidence of it, you have to be careful how you use that.
All right.
At the same time, you want to make sure your story's out there. So, for example, in the first trial in Deedy, the court allowed the jury to see the entire video. In the second trial, there was a separate issue, if I'm correct, that the court restricted the jury viewing what happened post-shooting. That Deedy was trying to render aid in his behavior, because the argument being from the defense that Mr. Deedy, in fact, was sober. That his behavior post-shooting reflected someone who was clear-minded, rational, and not intoxicated.
Correct. And the problems, as you alluded to a little bit earlier, with the whole idea of the videotaping and how does that factor in with the case, presents a whole different issue when we're dealing with how the matter unfolded, because basically those cameras are there specifically just for purposes of recording people coming in and out. They're not there to detail in particular and with particularity what happens in that setting, and you have a fisheye lens, and basically when it comes to trial, people are going to talk or testify about what happened, but it's from different views and different angles that are different than what the camera saw. We're used to seeing movies and TV programs where they've got 9 different camera angles, and we get a complete view, almost a 360 view of what's going on with an individual in the camera's eye. But in that situation, it's almost a myopic, flat view of what's going on. And so what ultimately happens is that the people who are in there tell the story as to what happened on the camera, and also a lot of times it boils down to who's got the best digital and video expert to tell the jury what happened.
I was going to ask you that. What could an expert testify to that I'm not looking at as a juror on the screen?
Go ahead.
You know, we all know eyewitness testimony historically is the weakest testimony. Yet people place the greatest, emphasis on eyewitness testimony. Now, the Deedy case presents an interesting dilemma. We have eyewitness testimony that's contradicted by the very videos. Each witness that testified had a different take on it because they perceived it differently. It's a traumatic event, it's anxiety-provoking. Yet we have a video it's not designed necessarily for anything other than surveillance, and everyone's basing their argument over this one video. Yet each witness had a different take on it. Even Deedy had a different take on what he recalls his behavior when he was describing how he cantilevered the gun, how he did one thing, and it appears different in the video, and it appears different also in the way the person perceives it, the jury or the person describing it to the jury.
Okay.
exactly. And recently I had a trial in which the video was really the centerpiece of the trial. It was a Hobbs Act case in federal court in which the alleged theory of the prosecution is that our clients went in, physically assaulted the owner of the club to take over the club, in effect. So we had an assault actually on video, and we had two assaults on video. One happened in the general bar area of the club, and the other one in the actual office of the club. And really, it really boiled down to the testimony of the witnesses and obviously the jurors' interpretation of what happened. It clearly looked like an assault, and it looked like an unprovoked assault that went in there. However, there was no sound, and we couldn't tell what happened before that, what happened downstairs, because that was not recorded. And so we had to have and lay out for the jury definite testimony definitively as to what happened, and we'd have to convince the jury that that's what the video was showing. And we had, believe it or not, there was divergent views as to what was on that video by the prosecution, by the FBI agents, by the defendants in the courtroom. Ultimately, the jurors believed what we told them, and they acquitted the defendants.
Is the video helpful? I mean, in this day and age, everything's being taped.
Well, certainly in the Deedy case, each side thought the video was helpful. The prosecution thought it presented a character who was intoxicated, acting irrationally, who provoked the situation. On the other hand, the defense was able to effectively show in both trials, certainly in the second trial, that what the video necessarily showed is not necessarily what happened. And in fact, he was able to demonstrate that the perspective of some of the jurors, as Bill was talking about in his case, just because it's shown on the video doesn't necessarily mean that's what occurred.
So we have videotape, we got all the witnesses there. Why can't we get a conviction? Or a clean jury break? We got hung juries both trials, even though they did acquit for the murder in the second.
Well, I think Bill, what he said a moment ago is correct. This is not made-for-TV movie. This is not live, ABC Sports where we have cameras on the playing field. The video cameras were set up for really a very basic purpose, to make sure that we have surveillance over the cash register, people coming and entering and exiting the restaurant, but it's not designed to be for forensic purposes. So it leaves these giant gaps so that each side has to bring someone in to define really what happened. And presumably have stopgap moments where you show this occurred. I know in the Deedy case that the attorney was able, Sturtaki was able to demonstrate that things were occurring that that the witnesses didn't see because they ducked behind an advertising display,
right,
or they went behind a chair, or they turned in a second. And the video doesn't show that necessarily. Someone turned. Plus, remember, everyone's watching something different and perceiving it differently.
Plus, you had in this case, obviously, the significant issue of self-defense. You've got an individual, at least in the first trial, the jury was told had cocaine in his system as well as alcohol, and he was being aggressive. It was clear by the video he was being aggressive, and the testimony of witnesses that he had approached and the like. And you have an officer there who is actually on duty 24/7. He has a weapon with him and is confronted in that situation and believes that his life is threatened. And that's specifically what our law allows for.
We're going to go to a quick commercial break, but we're going to get back to that. Now we're going to get more, when we come back, we're going to get more into self-defense, and actually was Deedy acting in self-defense based on what we know. And we'll be right back.
I'm Hong Jiang, host for Asia in Review on Tuesdays.
And I'm David Day, host for Asian Review on Thursdays. Both of us broadcast our respective shows at 4 p.m.
And my topics tend to deal with questions related to environment, culture, history, and sometimes human rights.
And my shows tend to be on international business, foreign policy, geopolitics, and national security. And you can watch our shows live on the ThinkTech website at thinktechhawaii.com.
And you can also watch us on YouTube or Olalo.
So come join us on Thursdays at 4 p.m. I'm David Day.
And on Tuesdays at 4 p.m., I'm Hong Jiang.
Aloha.
Aloha.
You can't keep saying ask and answer.
All right, we're back on the air with, we were talking during the break, with Myles Breiner and Bill Harrison, two of the greatest defense lawyers here in the state of Hawaii. We're talking about the Deedy case. And before the break, we started getting into first of all, what's self-defense? Over the last year, we've seen cases nationally, some that have been very, very divisive. Trayvon Martin, the Stand Your Ground law, all these things about self-defense. What is the law here in Hawaii about self-defense?
The law here in Hawaii, we don't have a stand your ground law. Only 23 states have that law. We don't have that. We have a castle law. Basically, the castle law basically says that if you're in your home, you don't have to retreat. We have actually, if you're going to be involved in a deadly weapons situation, you have to retreat if it's possible to retreat, okay? And if that's not possible and you're under threat of life or bodily injury, serious bodily injury, rape, or some serious felony, then you have a right to respond with that kind of power or response, okay? So Hawaii, unlike other states, we don't have a stand your ground law like Florida. And stand your ground law basically is this, is that if you feel threatened, you don't have to flee. You don't have to retreat. You can stand your ground and respond with deadly force. That's not what we have here.
Because the law used to be, and well, continues to be in this state, that the theory behind it is we'd rather see you run like a coward than take a life. Really, that's really the theory behind a lot of retreats. We'd rather see you retreat than take someone's life.
It's an evolving calculus in Hawaii. If the person provokes it, you can respond to protect yourself, but generally you have to retreat. Or if you can't retreat, then at what point do you stop and defend yourself? And then the calculus then looks at whether or not in that calculation, if you up the ante, have you picked up a weapon? You know, the person start with fists, and then the result is you defend yourself by grabbing some type of blunt instrument or a weapon of some sort, a knife or a gun. It's evolving.
Yes,
Okay.
but you're entitled to, for instance, a guy is 6'5" and 350 pounds, and you're 150 pounds. Okay, his hands may be a deadly weapon at that point. So you're entitled to level the playing field, so to speak, and possibly pick up a weapon to respond to. But you have to be in a situation where you believe it's a life-threatening situation. You're going to be raped. You're going to be substantially injured. You can't, in a situation where you don't feel that your life is threatened, you can respond with deadly force.
Right, so if somebody 3 feet tall kicks you in the knee, you can't shoot them.
That's exactly right.
Right. That would be excessive force.
That's correct.
And some believe that Deedy used excessive force when it came to fighting a man in McDonald's who was unarmed.
Well, in the circumstances, if the person has alcohol and drugs in their system and they're attacking you aggressively, and you show your credentials as law enforcement officer and the person does not back away, and you pull a weapon out and the person still doesn't back away, then we have a problem.
Yes, that's I got to disagree. Well, go ahead.
Because in this particular situation, Deedy is law enforcement. He's perceived to be, and he believes himself, the right to carry a weapon, federal law enforcement officer. So it's not an average citizen who has the duty to retreat or not to go to a different level.
But an officer's duty, an officer's right to self-defense is no greater than yours or mine. He or she has to believe that their life is in great danger of bodily harm before they can resort to deadly force. Right? So they don't have a special right to kill people, do they?
Well,
No.
I think the suggestion from the prosecution was that Deedy provoked the situation. His conduct escalated the situation.
That's my question.
Therefore, he can't take advantage of the escalated situation that he allegedly provoked to then assert himself and say, I have the right to defend myself, I have a right to defend the people here because I'm law enforcement.
One of the elements then is you can't claim self-defense if you did something to provoke the affray.
That's correct.
Unless, of course, you retreat.
Yeah.
You know, and you have clear opportunity to retreat, and then the person
That's that
stops
thing
you.
you're talking about, right? It's an evolving thing.
It keeps evolving. No, but that video reflects that it is an evolving situation.
Right.
I mean, he may have not. He shouldn't. It's all hindsight, you know, as it is 2020. Never involved himself with confronting the patron about being intimidated by the victim in the case. Okay, maybe that provoked the victim more. And the fact that the victim, at least as far as the first trial is concerned, was indicated he had alcohol and drugs in his system. That his response then resulted in a law enforcement officer feeling provoked or endangered.
But Myles and Bill, wouldn't you agree with me, just from your limited experience in Waikiki at 2 in the morning, wouldn't you agree with me that a lot of people in McDonald's at 2 in the morning may have some alcohol or drugs in or out their system and they're not getting killed?
Without a doubt. If you're out after a certain hour, the presumption leads to a DUI detail in Honolulu. If you're out past midnight, you're a target for the police. If you're out past 2 o'clock in the morning and you're in your car alone, it's a good opportunity to be pulled over by the police because you've come from a bar.
Remember our parents used to say, that nothing good happens after 12
There you
midnight,
go.
right? So there you
Richard
go.
Pryor had a skit on that too, be home by 11:30. Hey, but So that's my point. So isn't the prosecution kind of saying, look, people are down there like this all the time. It's not until you get there, after you've been bar hopping, and you come in there flashing your badge, being from the mainland, someone's dead. Right? I mean, you can go down there tonight and somebody's going to get smart with a patron.
Right. Plus, you have to keep in mind, Deedy was carrying certain subjective information. Right? He was informed by other people in the State Department division he was in that potentially he was a target because he was not local. That he had to be careful about how certain people react to him as not being local, being Caucasian. And this is in his mind, his belief system, which is legitimate. I mean,
yeah.
Especially if we're talking an EMED defense or something that changes it from murder in the second degree to manslaughter, is his perception of what's occurring.
Plus, you got the fact that if he shows his credentials and he shows the individual that he has a weapon and the person continues to come at him aggressively, in that situation, they're trained. You cannot let that person take your weapon away from you.
I agree.
Because in that situation, then you're in danger, right? And so, you know, it's a fine line when you feel as though your life is threatened, what you do. And if you're trained in a certain manner, you're going to react differently than if you're not trained.
But why are you even showing your gun? I mean, because no one came at him. I guess my point is, if it's going to be a fist fight, why are you pulling out your gun?
Because fist fights, you can be killed in a fist fight, okay? And the question then becomes, do you feel, and subjectively, do you feel as though your life is in danger at that point? Especially in a situation that if a police officer flashes his badge at you and shows you he's a police officer and he has a weapon, are you going to continue to confront him at that point? There's a question there.
But see, this is the reason why it's so close to my heart. When I practice out, and you guys know, when I practiced in Cincinnati, I did criminal defense work, but I did a lot of civil rights for families with people who black men were being killed by the police that were unarmed. And it led to riots. And so when I look at Ferguson and I hear people say, well, you know what, even though those people are unarmed, you know, the fact that they didn't respond, the fact that they, in fact, because they're bad people, they deserve to get killed. The fact that they didn't act right when a badge was shown. I mean, if a badge is shown and Edris doesn't believe that this man has any authority, I'm like, who are you? I mean, I could see it, you know, who are you to tell me what to do, man? You know, I'm not talking to you, I'm not bothering you. Now, the egos are meeting. Was it an issue of training then? That Deedy didn't have the proper training? My experience has been that egos, I think, you know, you get say for instance, a black male gets pulled over, and I'm sitting there in the car and I'm thinking, he pulled me over because I'm black. Now he's thinking, you know what, he didn't turn on his signal. He being a police officer, so he walks up, you know, show me your ID. What do you pull me over for? You know, now it just escalates, and I think that's what happened here. That's the Chris Rock scenario. Right. I mean, it escalates to where everybody, it's like testosterone all over the place instead of just saying, you know what? And I agree, that's not a place to battle. You don't fight or argue with the police. But I think Deedy conceded, correct me if I'm wrong, he conceded that he had a piece of the problem. He created this or contributed to the problem by his behavior. But after a certain point, he couldn't retreat. Then how can you claim self-defense? How can you come in here and start this mess and then say, okay, now I defended myself legally?
I don't know that he argued he started the matter. He argued that basically this individual was acting in a bullying manner aggressively towards some other patrons.
Correct.
He walked up and said, hey, you know, you shouldn't do that. You might get arrested, etc. And then it turned into, you know, an escalation to a fist fight situation where his friend was attacking his friend, Deedy's friend, and then he was being attacked. And so the question then becomes, at what point can you retreat, number one, but at what point do you have the ability to retreat when you're being attacked, punched, and kicked? And now, I'm not condoning that you pull out a gun and shoot people, okay? I'm not saying that at all. What I'm saying is that his defense was a proper defense because of the heightened situation that he was in.
I agree. I mean, I haven't represented police officers in that, but I've represented citizens who have shot people that were unarmed and reclaimed self-defense and actually won. And that's what I was... Because it's hard to me it's hard to prosecute claims of self-defense and get convictions when there's some evidence out there that supports that the other person really wouldn't stop. Well, that appears to be the case in, you know, with the Deedy matter. I mean, Deedy approached him, as Bill said, asked him to chill out, in essence. His response was a response I don't think Deedy was anticipating.
especially after he identified himself as a police officer. And rather, normally you identify yourself as a police officer, the usual response, and Deedy expected it, would be, look, okay, I'm sorry, officer, and you back down. But the response he got was anathema to his training at the same time, and completely unexpected. This person would want to become even more aggressive and then engage in a fight with his friend and then ultimately with Deedy. And thereupon, that's why I think the jury ultimately found him not guilty.
And I think that's the argument basically is, you know, that he went up there, tried to talk to him, that didn't stop him. People tried to intervene, that didn't stop the victim from continuing to attack. Deedy showed him his badge, that didn't stop him. Showed him his gun, that didn't stop him. What stopped him?
A bullet.
That's basically it.
And that's, yeah.
Yeah, and the jurors, obviously, they see and they're told what happened there. They see the whole circumstances that evolved, and even though they're instructed not to place themselves in the same situation when deciding a case, they're supposed to decide objectively, right? You have to, as a juror, think, okay, that's what happened. You know, in that situation, I may have done the same thing.
Well, that's why it's hard. But in this case, why do we see so much division on the jury, both jurors?
Well, I don't know we had that big a division. I think the first case was 8-4.
Right.
And we don't know what the numbers on the second case was, but obviously they acquitted him of the murder.
But
so
we'd
they weren't
agree
really,
that we all agree that it was never murder. Or do we disagree?
Well,
I don't think we disagree. I don't disagree.
Yeah,
with that.
no,
I think
obviously
the case,
the jury spoke.
And we see this all the time. The case, first off, was overcharged.
Right.
That's my point.
And they did that intentionally because their fallback was they asked for manslaughter. Now, they didn't in the first trial. They insisted, or maybe they were overly confident, that the jury would buy the video and their interpretation of it, that it was clearly murder in the second degree, that he was intoxicated. The jury hung 8-4, as Bill said. The second trial is interesting. We had the Evento case that came down. Okay. There was a discussion before the jury trial about giving a manslaughter instruction. I submit, and I think Bill would probably agree with me on this, the case should have been charged manslaughter to begin with.
Did the state ask for it this time? Now, I know the judge gave the lesser included, but did the state ask her to charge them with manslaughter?
In the closing argument, the state did not want the jury to consider manslaughter. Their argument was this was murder.
I've never seen nothing like that before in my life, man. To this day, I've never seen that.
And now they're faced with an interesting conundrum. They want to go back and re-prosecute a third time on a theory that they specifically, in 2 trials, consecutively said there is no evidence of manslaughter, and now they're going to embrace it. And the sad thing for Mr. Deedy is that they'll get a third trial, and then they're going to still go for enhancement and try to get a life sentence out of the manslaughter.
That's the scary part. And the question is, are they going to be prohibited from doing that? Now, there's some good arguments that they shouldn't be able to retry this case. But ultimately, the judges make that determination.
Yeah, but you used to be a prosecutor, and you've been going against prosecutors all your career. I mean, the state prosecutors have a duty different from ours. Their duty is to seek and do justice.
That's right.
Right? That's their ethical duty, right? Which is different from any other advocate. I mean, we're advocates. Right. You guys are advocates, right? So when you say twice, I don't believe the evidence shows manslaughter. We don't believe the evidence supports manslaughter. We didn't charge on manslaughter, and you're on the record twice saying that. To come back now and charge me with something that you truly don't believe I did,
well,
is a problem.
And they have the ability to fall back on, well, the case I'm thinking is Milwaukee.
Yeah.
I mean, theoretically, certainly Mr. Otake is going to be filing a motion to dismiss the case based upon the case being tried twice. Unfortunately, because the court gave the manslaughter instruction for the second trial, technically the case hasn't been the same evidence in both trials. So Milwaukee wouldn't apply, and they'll go to a third trial.
Well, I still want to get back to this point when we come back from this break, because I truly believe that case aside, there's a due process argument that Deedy could make, and I believe personally, I believe he should have been convicted of manslaughter, but I also believe that the state should be able to try him again. But we'll talk about that when we get back.
Aloha, my name is Willow Chang Alion, and I host a show called The Art of Life. We air live every Friday from 2 to 3 p.m. And what we do is basically we focus on individuals who create a unique sense of place for Hawaii. These are movers and shakers, artists, innovators. They are also traditionalists. They're all involved in the archival process, and they make this place a unique place, one that makes Hawaii a richer place to be. I hope you do join us, and certainly tell your friends about the show, whether they live here or they live abroad. It's a way to give back to our community. We're keeping it
Disclaimer
on
on the airplane.
Yeah, I love defense lawyers. You know that, man. I love trial lawyers. We're back on Life in the Law. Again, I'm your host, Kenneth Lawson. And with me today is two defense attorneys, two of the best defense attorneys in the state of Hawaii, Bill Harrison and Myles Breiner. And we're talking about the Deedy case. I think there's going to be a hearing Friday about whether or not he should be retried.
Correct.
And again, I think personally that I think it's a manslaughter case. I think he had something to do with starting the affray and should not be able to claim self-defense. However, I do think that since the state has not asked for manslaughter, since they've came out on the record and said that they don't believe there's any evidence of manslaughter, they should be precluded.
I submit this is the hypocrisy of prosecution. They should be held, their feet held to the fire on what they've done in the last two trials. They took it to grand jury and they told the grand jury this man's guilty of murder in second degree. They presented an argument the first trial, and they were emphatic. There was no manslaughter. In fact, they insisted no jury instruction of manslaughter should be provided. Right. Mm-hmm. And the judge went that route. Even at the second trial, despite the fact the Supreme Court came back and said the court must give an instruction if even the slightest scintilla of evidence warranting a manslaughter instruction, they still insisted in opening and closing that he did this intentionally, deliberately. Now, the irony is that they're not going to go back to trial, because I have a feeling the court's going to probably deny the motion for the defense to dismiss the matter, and they'll proceed to a third trial, and they'll move to strike any reference to the first two trials so that the defense is precluded from raising this issue of the inconsistent argument and theory of the prosecution, and they'll probably get a conviction on manslaughter. There's a good chance of that now.
Yeah, like you said, what are they? They're the Department of Justice, in effect. They're supposed to be there, and they are supposed to be there to protect citizens and to provide the courts with justice. Okay, when they take a position and then they're saying no, that's not what happened. This is what happened twice. Okay, they should be stopped, prohibited from arguing that position at a later time.
Because now
that's not going to happen.
But now you're prosecuting me for something you said that I didn't do.
Exactly.
I mean, it'd be different if you just shut up and didn't say nothing. But you've already put on the record twice that you don't believe I committed manslaughter.
That's correct.
My personal opinion is that the defense counsel should move to recuse the judge that heard the case the first two times. Yeah, this juncture, you need fresh face.
Well, even with the prosecution, though, Myles, I mean, you guys have been doing murders, and I've done my share of murder. There's always a murder and then the manslaughter, and if we go to trial, the state is always asking for the lesser included offense of manslaughter, because if I can't get you on murder, at least I'm going to get you on something. The only thing I can think of, and this is just my conspiracy theory, it's almost like they were trying to throw the case.
No. I really think they had a local...
well, it ain't murder. We all agree it's not murder, right?
No, but they presented it, them versus us. And you can't constantly... Look at our local politics here. We just went through a primary period, and a lot of the politicians, instead of saying, I'm from Hawaii, they said, local. I'm local, implying that our President Senator, Brian Schatz, is not local, even though he's lived here most of his life, and his children are from here, and his kids are Hapahaole. But they still presented this them and us mentality. Mm-hmm. And that was clear throughout the first trial and the second trial that he's not from here. His attorney, Caucasian. His second chair, Caucasian. In fact, one of the comments I heard during the trial was he should have gotten a local attorney.
That may have been some of the problems. That may have been some of the problems why the jurors were hung. But I'm saying when you have, look, when I'm prosecuting, and that's what we do, we work with law enforcement, they're our brothers and sisters. So even if he is from the mainland, he is still an officer, he's still a, so if we keep him on murder and we know it's not murder, the jury, it's always going to be hung. You can't convict on murder because he didn't, even if you believe he was wrong, he didn't do that.
I personally believe if it was a local police officer who was involved in the shooting, one, it probably wouldn't have been charged by Keith Conashiro, the prosecutor's office. He would have punted it over to the AG's office or the U.S. attorney. In fact, that's been the hallmark of this particular prosecutor, is that he doesn't go after cops. So the question arose from the defense attorney. I know Bill thought about it. I certainly thought about it. Other defense attorneys. What a logical target to go after. A mainland Hawaii law enforcement officer involved in a shooting of a local guy. So the question is, why didn't he ask for manslaughter?
Yeah.
Because I think he believed that he would get a local jury angry enough and they would convict him of murder in the second degree.
Okay, that's possible. Okay,
Yeah, that
And you
is.
guys have been here a lot longer.
Because all of us were surprised that Jan Fuda didn't ask for manslaughter instruction.
Oh,
yeah,
shocked.
That was,
absolutely.
I mean, everyone was
They
saying, wait a
always
minute,
ask.
what's going on?
Yeah.
Yeah. And I can see why Brooke didn't do that.
Yeah.
Well, obviously, you can't argue self-defense and they're inconsistent.
Right, exactly. And so, you know, the bottom line here is that under the circumstances of this case, the state made a bad decision.
Right.
Okay, and that's why it wound up the way it is.
And now they're
right
trying to
now.
dig themselves out of a hole.
But even if the judge says under Moraki that there can be a new trial, the state can still say we're not prosecuting, right?
Oh yeah, they can say we're not going to choose to prosecute this matter, and if they told Tommy Otake that now, he wouldn't file his Moriwaki motion. That'd be the end of it. Okay,
But they're not going to let it go.
well, Jan Fuda in the media has already said that she's looking to recommend that this case be tried again. Okay. Now there's a corollary issue here. There is this ongoing sort of bad blood situation between state and federal law enforcement as well. That may be an undercurrent in this thing as well, because recently I represented an individual who was a commander of Homeland Security who was charged by the state with terroristic threatening when we believed there was no evidence to support that charge. In fact, the evidence that was out there was contrary to that charge. And ultimately, we removed that case to federal court, and we got a dismissal with prejudice in federal court. But that individual's life was on the line on really the statement of the complainant in this case, claiming that my client pulled a weapon on him and threatened his life, where there was really no evidence of that.
So the good thing about moving stuff to federal court is it kind of takes the politics out of it.
Well, I think in that situation, it would have leveled the playing field, and it did in our case, especially in this kind of a case where the individual's from the mainland. He's part of the State Department, right? Mm-hmm. He's gonna be in an environment which he was in, which is going to be pro-local in the state court. All right, and federal courts traditionally, historically, have been the area you go to get out of that situation where you're in a local environment in terms of having your case adjudicated. So that's why we have, in situations with diversity, you can move your case to federal court. And in this kind of a case where if you're on duty at the time this offense happened, rose out of the course and scope of your employment, you have a right in the Constitution as a federal employee to move it in the federal court to have the federal court or the federal court judge or the jury decide the case.
Kind of reflecting the evolution of civil rights litigation. For years, the push was going to federal court to get an even playing field, as Bill and I repeatedly said. Mm-hmm. But that started changing after the Reagan years, the Republican administrations, the 2 Bush in a row, and you found the federal system no longer was a place to go to.
Not for civil rights.
Not for civil rights. They said go back to the state courts where there was a strong democratic, more liberal position taken. So it's an interesting dynamic, and as Bill said, there's some problems in our between the state and federal, and city and county, and law enforcement in the prosecution of cases. Bill was very fortunate in getting his case over to federal court, got the right result with the right people. Had his client, I remember the case in the paper, had the case ended up in state court.
You might have had a different situation.
And to get it dismissed with prejudice means that somebody was really kind of.
It's a message.
Yeah, it's a message.
There was no case.
Yeah, and don't bring it back here like this again.
Correct.
Exactly.
So going back to that first time jury, do you think, that race played a part in it and why that was hung? Because we all agree it's not. Let me just put it like this: we all agree it's not murder, right? This last jury agreed it wasn't murder too. It can't be murder, right? I mean, so.
I'm sorry, I'm biased. I really believe that race was a factor in the.
You think some people were holding on, saying, "I'm not going to let him go"?
Well, from the very beginning, for the investigation of the case, the decision to keep it at the prosecutor's office and prosecute it, what they took to the grand jury, how the grand jury, the information they were provided, all that to me suggested there was a racial factor here. Now, we have on our books here hate crime laws. In all the years that I've been here, Bill, have you seen a single case prosecutor using, even we had cases where people were assaulted over at the Home Depot,
right.
The military couple, and the guy beating on the husband and wife and their child was screaming at them, regarding their racial identity, about being haole and so on. the prosecution refused to charge as a race-based crime.
You know,
People don't want to admit, look, no one wants to admit they're biased, okay?
And that's the point.
And every time we get a jury, for example, when I had recently a jury trial, my client was from South Florida, a Rastafarian, he had the dreads and the whole bit. I had to ask the jury in voir dire, where would you want to go to trial? In South Florida, Chicago, New York, or Honolulu? Every single juror, regardless of their ethnicity, said here, in Hawaii. I said, why? Oh, because the people here are like me. So race is always a factor. And Deedy was going, it's an uphill battle for him in the first trial and in the second trial. And unfortunately, with the prospect of a third trial, yeah, it's unfortunate because the prosecution won't give it up.
You know, and we always want to believe that race is not going to infect our case, okay? But the reality is, as a defense attorney, you have to think.
Right.
Whenever you have someone of a different race, you have to think, and you have to be an advocate, you have to prepare for that issue and argue that issue before the judge and the jury.
All this is
and on voir dire, you have to bring, I mean, because all of us bring our past experiences to it. So, I mean, if I'm walking, like Jesse Jackson said, if I'm walking down the street in Chicago and there's two big black guys behind me, you know, the truth is, I think they may be trying to do, you know, so even all of us bring our own stuff. There's nothing wrong with that, but we got to talk about it.
Right.
Almost every trial, as a trial attorney, we always ask the juror, how do you know when someone's telling the truth? We ask them to go through the whole criteria. And everyone feels that they're the great arbiter of truth-telling and veracity. You know, the facial expression, hand gestures, body language. Well, Hawaii is an unusual place. First off, we have certain ethnic groups here that facial expression is frowned upon, that you keep a placid expression versus having a very animated expression, or eye contact. Certain people consider eye contact, depending on your ethnicity, as a sign of hostility. So it raises certain issues, and you have to address this every time you're in front of a jury, no matter what, and especially in Hawaii because of the groups of people that we have here.
And I think, you know, I'm writing an article for Law Review now on expanding voir dire to do just that. I think that we'll see less convictions based on race if we can talk about it.
Correct.
You're going to have it, you know what I mean? But does that mean that my client did it? You know, we don't have to get into that.
I've seen Bill in trial. Bill addresses it. I raise that issue. But a lot of our colleagues are hesitant, especially some of the folks that grew up here, because it's an uncomfortable thing. We're the Aloha State. People don't want to identify the fact that we have a lot of racism here. Like, I'm from Detroit, Michigan.
No one wants to hear it.
When I moved out here 30 years ago, and I called up friends and said, hey, you know, there's a lot of racism here. I'm tired of be calling, you know, an F and Howley. And their response was, now you know what it's like to be black in America. So, you know, it's...
Exactly.
Yeah.
And I think a lot of trial judges have to kind of let the lawyers do that and believe that the adversary system will allow this to come out, but we have to be able to talk about these things. They're not comfortable to talk about, they're ugly, but they're real and they affect people's lives in court.
Oh, absolutely, and that's one of the problems that we're facing, and Myles will tell you that a lot of the judges, because of time constraints, because of their heavy caseloads, will not allow us a lot of time in voir dire, and that's the most important time.
And juries are opposed to convict.
The trial. Yeah.
Exactly. Juries come in predisposed to convict. No juror comes in thinking, what did they accuse him of doing? They come in thinking, I wonder what he did.
Yeah,
well, how do you explain it? When a judge says in a Class A felony trial, you have 20 minutes for general voir dire and you have 5 minutes, you know, with each respect. You can't do it.
You can't do it.
No, because most of the jurors aren't focusing until they're actually in the box.
Exactly.
And then they're really responsive. And then you're in this time crunch, and supposedly you're getting a jury of your peers.
Yeah.
I'm thinking of my Rasta client, and I had to ask the jury, are there any peers of my client in this room? I asked all of them, you have any black friends?
Exactly.
All right, I think we're at the end of our show. This has been a great show. Hey, Bill and Myles, thank you. You'll see these gentlemen around Honolulu. Say hi to them. They're very personable, but they're extremely good at what they do. That's defending the rights of those that can't defend for themselves. Again, my name is Kenneth Lawson. I will see you next week, same time, same place.